A common tactic disability insurance companies use when evaluating a long-term disability claim is to delay the review process, right? Whether it's because they're always waiting on more information or their medical team is reviewing the medical records. Almost always someone calls us complaining that their claim review is taking so long and they just don't know what to do. First, let's look at the reason this happens, right? One of the common reasons this is happening is because a delay is harmful to you and helpful to the insurance company, right? It puts financial pressure on the person who is waiting for that first disability check. And so you have to imagine that many people just give up and walk away. If someone's disability claim is governed by the federal statute called Erisa, which the great majority of disability claims are, then there's some good law in place to address that specific issue. In 2018, the Department of Labor amended regulations that now require insurance companies to make a decision on a disability appeal within 45 days. And yes, they can take an extension if there's special circumstances beyond their control that requires them to take an additional 45 days. But what was really important in the amendment back in 2018, it's for the first time there are consequences to the insurance company for failing to abide by a decision deadline. And what that is a claimant, the person who has a disability claim, is now able to file a lawsuit against the insurance company because of that delay. And in many instances, they get a favorable standard of review in federal court, which gives them a legal advantage. And that's a conversation for another day. But the point, the takeaway here is that nobody should sit through an insurance company dragging out their claim. There are legal mechanisms in place to shut it down. The problem is not all attorneys are using the law to their clients' best interest.